Navigating the Digital Justice Landscape. Insights from Graham Ross on ODR and AI. That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hey everyone, this is attorney Mac Pierre Louis, and welcome back to LMI Podcast and this series called Megatrends Revolutionizing Access to Justice with Thomas T. Giglione. All right, so everybody, welcome back. And Thomas, thanks so much for coming on. Why don't you introduce yourself and our guest?
Yes, thanks, Mac, for this opportunity to introduce Graham Ross today to speak. I'm Tom Giglione here in Toronto at We Agree Mediators. Graham Ross is a member of the International Council for Online Dispute Resolution, advisor on online dispute resolution to court systems worldwide, including Ukraine, mediator specializing in shareholder disputes. Welcome, Graham.
Thank you. A pleasure to be here. Thank you, Thomas and Mac, for inviting me. It's you pulled together a fascinating series of podcasts. There you are. There's all the praise to my host.
Awesome. Thanks so much.
Yeah.
Thomas, before I let you go on and start with some questions, just wanted to bring some attention to Graham's website. If people want to know more about him, they can go to theresolver.com. See You Out of Court is also one of your brands. And so we'll be sure to put all your links, Graham, on the bottom of the show notes. And if you're listening to this, it's theresolver.com, RESOLVER. Just wanted to make sure that folks know where to find you. All right, go ahead, Thomas.
Will do.
Yeah, so before we go into the deep dive and have a conversation with Graham, I know that you been involved with a lot of conferences this past year. And if you could just talk about the conferences where you spoke in Vilnius this year, and you have an upcoming conference in Greenwich. If you just give us a little bit of background about that.
Yeah. Well, in 2002, we formed the International Forum on Online Dispute Resolution. That was formed by the Center for Technology and Dispute Resolution at the University of Massachusetts in Amherst, under the guidance of Professor Ethan Cash, who, with the support at that time of the United Nations Economic Commission for Europe, they formed the International Forum, the first International Forum on Online Dispute Resolution, as long ago as 2002. This was in the Palais des Nations in Geneva, and I was there. We're now coming up to the 25th quarter century, which is terrific, of these forums. They get bigger and better every time. They gather in all the experts around the world, all those people who've been working hard at researching, developing, advancing essentially the application of technology to dispute resolution. What's fascinating in that 25 years, and I must have presented it at least 21 of them, is that in the first half, I suppose, and more than half of those, ODR used to have a hidden letter in it called and letter A. It was really OADR, with the A standing for alternative. So in other words, it was about online alternative dispute resolution, how we could go online with arbitration, mediation, and all other forms of resolution that share the one characteristic of being out of court. And what has happened more recently, particularly since the pandemic, of course, is that hidden A, has gone away, because now, of course, the courts are increasingly looking to technology to help improve both access to justice and the delivery of justice. Firstly, in the immediate problem that they have since the pandemic, most courts around the world are suffering with a massive backlog of cases. They just can't deal with it. So anything that's going to help parties to resolve their differences without going to court is welcome, particularly if they pay the court fee beforehand. But so this is, and the most recent ones that I've spoken at, was earlier this year in Prague. That was the 24th forum. And then prior to that, I spoke at an event that was not part of the forum series, because that's another thing, is that for most of the last 25 years, the only ODR conferences have been the International Forum. More recently, almost every conference on alternative dispute resolution, on mediation and other ways to resolve, and indeed on ways to resolve through the court system, have included presentations on ODR. So it's a subject that is rapidly expanding. Yes, the one before was in Lithuania. It's my second conference I've spoken to in Lithuania at the Mykolis Romeris University. That was really a conference, excellent conference on mediation. And I presented on how technology can both make mediation more available, more cost effective, and more effective for people to look at. The most exciting thing is that the 25th forum, I'm honored to have been invited to host this in my home city of London, now home city. I should say my real home city is Liverpool, where I put on and hosted the 5th in this series in 2007. But I'm now going to do it not just in London, but in the Royal Borough of Greenwich, housed in a World Heritage Site, being the old Royal Naval College buildings, birthplace of Henry VIII, Elizabeth I, great historic, and overlooking the Royal Observatory, which is the beginning of time, the joining of the Eastern and Western hemispheres. And I'm really excited to be putting the 25th, the quarter century of these forums, on there in Greenwich in conjunction with the law school of the university there on the 29th and 30th of April next year. And it's really going to be an excellent. We haven't yet got our full, we're getting lots of requests to give presentations. I'm pleased to say that we have 2 excellent keynotes already lined up. One being the second highest judge in England and Wales, the Master of the Rolls, Sir Geoffrey Voss, who is very supportive of the introduction of technology in the justice system, and also Professor Richard Susskind, who you may know is quite well known as a writer on the impact of technology on the developments and future of law. He'll actually will have just had his latest book published a month before the forum, which is on AI, more generally for AI in general, rather than just in particular in relation to the courts. So there's lots happening. And thank you, Thomas, for allowing me that plug for the 25th forum. The website's not up yet. It will be, and I'll let you have it, Thomas and Mac, to let everybody know if you want to find out more about it.
That's great. Mac and I were discussing maybe we might be integrating our podcast, LMI podcast, and invite some speakers, synchronously at the same time. And Mac, it might be a great honor to even invite Professor Susskind to speak on our podcast. And we look forward perhaps to coming out there and joining the conference next year. What is the date again, Graham?
29th and 30th of April, 2025.
In the spring. Okay, great. We look forward to that. Graham, I met you through iCoder, through Colin Rule, who we had on this podcast before. Mac and I are now members of iCoder, and I know you're a pioneer of iCoder. Can you just briefly give an overview of your involvement with iCoder and the courses, and how iCoder aligns with with online dispute resolution, especially setting up a code of ethics and such?
Yes, yes, indeed. So it really comes out of the fellows of the National Center for Technology and Dispute Resolution at University of Massachusetts, who started, I mentioned before, to run the International Forum. And after we'd had it in Paris, and we've been all over the world, by the way, as you can imagine, it was decided to set up the International Council for Online Dispute Resolution. I was one of the founder board members of that. I've now served my term, but still an active member. And it brings together, therefore, through that heritage, some of the most well-known, put it that way, writers, presenters, researchers, developers on online dispute resolution. So it's a unique connection with that. Anybody can join. We have regular meetings online. Oh, there's a picture from Paris on our formation.
Yeah, lots of faces that you know about that one.
And
No, lots of. Oh no, I'm sorry. I was just mentioning that there's a lot of faces that who we're familiar with on this group.
Yeah,
yes,
they've been on our podcast.
Yes.
Yeah, there's Ethan towards the left there, Dan Rainey, Colin Rule. You mentioned Colin, of course.
Yeah,
really one of the pioneers with Ethan. Colin, who developed the systems for eBay and PayPal, and very much the birth of ODR came out of the developments in e-commerce and technology with the web, of course. So iCoder is the must-join organization if you want to just easily keep in touch with developments, not only developments that have happened, but thoughts and ideas moving forward. And many of the members of iCoder are quite influential in that area, so that a lot of the discussions that take place, many of us have been involved in our own country and organizations looking at and researching where ODR is. So iCoder is the place to join. Thank you for giving that mention, Thomas.
Thank you, Graham. Let's talk about integration of AI in the courts. You mentioned that in the 2015 Civil Justice Council report recommended automated negotiation systems without human intervention. How do you see this vision evolving today, and what are the main challenges in implementing AI-powered negotiation tools in the court system?
Yes. Well, in that report, we certainly mentioned what you've just said, automated resolution systems, but it was within the context of what we would see in future generally, not specifically. But and I have to say that if it sounds a bit advanced, if it sounds a bit, well, that's going a bit too far, let's look backwards a little bit. So I said that these conferences were started in 2002. So that's a mere 22 years ago. Imagine, and let's look back at how things have improved and changed, and what we all can see in our life, how technology has radically, in those 22 years, changed all elements of life, not always for the better, but significantly. And just imagine the next 22 years. If we've had that amount of fantastic development, where people have easy access to the courts by just filing papers online, where various systems, people I advise, Smart Settle, that have systems that can actually help people resolve their disputes rather than just manage the disputes. There's no, it's not just about looking to the horizon. Looking beyond the horizon has got to include automated systems. I mean, if we wanted to really let the imagination flow, why not eventually a systems whereby anybody in a dispute could go somewhere online, could write and enter all the details, could enter the evidence they have. The other party could be invited to do so. And because every case, every situation, the background, the detail, the evidence, and the decisions of every case are posted somewhere in some area, online receptacle where they can there. The system using AI, I mean, the way AI has just flown away into a huge, bringing the future here with us already now, with AI working on neural networks, has had an amazing development. Those systems then could very easily interrogate all the way similar cases have been decided and come up with a resolution without the intervention of any human at all. Obviously, this is the problem that people have. We can't have that. We can't do away with the humans. But looking forward to unlimited future, why not? AI is already blowing our minds. I had a client last week who suddenly wrote to me that all sorts of research he'd found on AI. And I had to offer him a job when the case was finished. But he was very good at it. But no, I'm sure lawyers all over the world are finding clients accessing AI apps and things like this. Why not? Yes, of course, it's tempting to say we will always need humans. And my big thing in the short term is to look at AI in a slightly different way, not as automatic intelligence, but as augmented intelligence. In other words, apps and facilities that will actually augment the skills of the human lawyer, mediator, whatever, and help them to do their work better. And eventually, we may well get to that point where there are no judges. Like insurance companies already have access to massive databases by which their case handlers on the office floor can better guide and negotiate the value for a claim. This needs to be available to claimants as well. We need to know, if you just had these databases of all the way cases have been dealt with and how to value, it would make it much easier to agree on the value of any particular case. So although we just threw it in as a line and saying we want to see the courts have a second tier with all sorts of developments that would help people resolve should be included, including fully automated.
Thank you for sharing that, Graham. Thank you for sharing that, Graham. Just highlighting the title for today, Navigating the Digital Justice Landscape. So there's the vision of navigating this justice landscape implies interoperability of the ODR systems. Graham, you discussed the problem of new digital systems not communicating with older paper-based ones. How can we ensure better integration between the various dispute resolution platforms to create more seamless justice system navigating through these two paradigms?
Well, that's the big issue to me, is not so much what developments, what great ideas, what great apps, what is AI is doing. but it's about how is it being implemented. And there we get down to human beings. So there we get down to how do the courts actually implement these. Now, and this is where the danger is, that if they're not implemented to a certain standard, I mean, you can talk about the online experiences but I'll give you an example of what I mean, really, which is something that really bothered me. I took a court action out in what's called the online civil money claim. This is it's about 4 years old now, and it sits alongside a much older system called Money Claim Online, and these cover separate. But for the cases up to £25,000 in value that are just a money claim, you go now to the Civil Money Claim Online, which is court, which is online, ease of access. And I issued my claim through that. I really wasn't bothered about suing. It was, I just wanted to experience what it's like actually as a litigant. And I raised the case, and a defense was filed. I received an email with the defense from the solicitors for the defendants. And then we actually had a meeting to try and settle it. The next thing is, when I go online, I was seeing a message that says, because the defendants have not filed a defense, press this button and you get a judgment in default of defense. And I thought, well, this can't be right, because I know I've had a defense. They've sent it to me. We've talked about it. So I thought, well, I can't take advantage I can't press that button, because it would be wrong and they would be able to set the judgment aside. And I wanted to be fair. I wasn't really particular about this case, although they did settle and pay me what had been claimed. Anyway, I got in touch with the court staff, and it turns out that although they're operating the new civil money claim system, and they still have the old legacy system, the paper-based system that now simply allows that. Actually, what you're showing is a slightly different one, if I may come to that, because that's the money claim online. Let me just finish what I wanted to say about my case, and we'll come back to what happened was that the solicitors filed the defense by sending it to a specific email address of the court that they were used to using, as was the recognized place to send a defense. But apparently it turns out that whoever set up the new online system failed to ask it to check, before deciding a defense hadn't been filed, whether defense had been filed in the old system, the old paper-based system. It didn't do that, and that's why it was saying to me I could enter a defense. And you're like, such a stupid mistake and oversight to make. This is the problem, that when very good, clever technology is implemented, we have to make sure people buy into it properly, they understand it, and that it's actually operating side by side. Now, they say they've fixed it by making sure before they announce that the claimant can enter judgment by default, to just check that it's not, a defense hasn't been sent off system. Now, the one you were showing me is an earlier system called Money Claim Online. So in England and Wales, it's they have, in a sense, been long ahead of the game in this, because this system goes back, I think, to the about 15 years now, if not 20 years. And it looks it, doesn't it? This is a very old school way of running an online service.
I wasn't sure where the other one was.
All the others, with all the other, when you go into the system, but it's like that all the way. and that doesn't help. So we've
Yeah.
got first making sure new systems talk to the old legacy systems that are still operating. And that what you're looking at now is GovUK, the government's website that links you to Money Claim Online. It's a little bit more modern and easily navigatable. But the one you first shown was Money Claim Online. That is very unnavigable. We need to give more attention to the way implementation takes place.
Well, thank you for that answer. Where you are now in England, it's a place of tradition where Magna Carta started, and we have case law. So I was wondering if there's a dichotomy, balancing innovation and tradition. You mentioned the tension between replicating existing processes digitally and taking a more innovative approach. How can the courts strike the right balance between these legacy systems and embracing technology advancements, especially now with the general AI coming to fruition over the next couple of years?
Yes, that's a good question. And for years, courts all over have developed tradition, the robes, the wigs, the way that the practitioners address each other, the traditions of it, has always been important because tradition generates respect. And the law always needs respect. You don't always get it in certain governments around the world, no names, but respect for the law is critical and crucial to a peaceful society. Is there a danger that technology will disregard that and somehow make the courts, the experience of going to the courts, much like buying something online from Amazon or booking a ticket to the theatre? We have to think about what's more important. It's easy to say these systems need to still embrace these traditions, but I think there's a danger there. Look, as long ago as I think it's 1880, this is the real problem here. 1880, an Irish judge was having a bit of a meal with an English judge, and they were comparing each other's systems. This is not an Irish joke, by the way. It may sound as if I'm beginning to hate one. So they were having a dinner, and then they had an argument about whose system's better. And the English judge was saying, "We have a wonderful system. Cases go smoothly." And the Irish judge said, the Irish courts are wonderful, but the English courts are said to be accessible to everybody, like the Ritz Hotel. In other words, that anybody can walk into the Ritz Hotel on Piccadilly, is it? But if you want to enjoy an evening, a night in a room, you have to have a lot of money. So in other words, what we're really talking about was the fact that we have this wonderful court system, but most people can't afford to use it. What's the point of a legal system if you can't afford to use it? That was in 1880. 4 years ago, the Lord Chief Justice here in England said more or less the same thing. The problem is that most people can't afford. Court fees have gone up astronomically just to issue proceedings. And in my work, I'm a mediator now, resolving disputes for shareholders, people who own businesses, the disputes they have. I tell you, so many times the clients tell me they just can't afford to sue, even though they have a good case. So that's the key thing. I mean, tradition is important, but I'm sorry, it's not as important to me as access to justice. And if that justice is accessible because it's using technology and allowing for the fact that certain parts of certain people won't have access to the technology or the skills, and we have to allow for that. But that tradition comes nowhere near getting it right on the technology.
Mac, did you have a question for Graham?
No, I mean, I love listening to Graham, and so I
Yes.
appreciate the thoughts because I was just thinking, and some of the courts I've worked in, you might I've noticed that some parents, because I did a lot of family law, I would notice that parents would go to court dressed in ways that, in my opinion, show disrespect for the court. And the courts got serious about this. They would, back in the day, kick you out, or the bailiff would come and escort you out and say, no, there's certain, decorum of court. You have to dress a certain way. And that's one thing. So I totally agree with you that tradition breeds respect and people have to do this in a certain way. All right. There are rules of court. On the other hand, we now have invited Zoom into the courts. And now these same parents are able to get online and access the court systems in ways that make it so convenient and easy. They don't have to, a mom doesn't have to, for example, have to go get daycare for her children. She could put her kids in the other room while she goes to court. Before, that was a big cost to her. So the access to justice component now is available because of technology. So how do we balance it, right? And you're trying to strike a, a good balance between being kept out of court because of certain rules, but at the same time
Well,
wanting
mm,
technology to progress and give ability for people to go to court. And so I guess the question for me is going to be, how do we make sure that respect is going to be maintained in the age of technology and ease and convenience
mm.
and AI?
Well, to me, the idea that a court would treat a litigant differently just because of the clothes they wear, actually, I, I would find that particularly abhorrent, really. I think the fact is, of course, what clothing is considered disrespectful varies according to the viewer. I not so long ago, every day I put on a pair of leather shoes. These days, when I go around or go into even meetings in law firms, everybody seems to wear sneakers these days, even with suits. And I don't know, I mean, fashion changes, unless they've got a T-shirt with some phrase that is particularly rude and disrespectful to the legal system, you might draw a line there.
Yeah.
I think tradition in dress changes, its fashion, and surely the respect that you show to the court should be because of the way the court treats you and treats the people that come into the court. But there are limits. I fully agree, and foul language in the courtroom and etc. There are limits, and you draw lines. But I don't think that should be any reason to limit the drive of technology. But inevitably, if your court experience is from your bedroom on a laptop, it's going to hard to actually express what tradition expects. What does tradition expect? We now have. I mean, one of the saddest things about these conferences, and I've been all over the world in conferences and very enjoy giving presentations, but I hate doing them online. I hate it when at the end of this conference, instead of being able to socialize, have a coffee or a drink, or go out to dinner with some of the people you meet in the conferences, you're struggling to find that little red button that says leave, and that's the end of the conference. So yes, I think I agree with you, but I don't think it should have any particular effect on the way technology develops, put it that way.
I have one final question, Graham. We spoke earlier about Colin Rule as being one of the founders in dispute resolution, and he had his founding from e-commerce with PayPal, as you mentioned. 2 years ago, I wrote a paper when I was living in Vietnam about the developments of e-commerce on dispute resolution mechanisms. And I notice a lot of e-commerce platforms now, what you do is there might be a dispute, like for example, freelancer.com or other dispute or other e-commerce websites where each party uploads their documentation and basically waits for AI to sort everything out and come to a resolution, almost like a med-arb arbitration type of thing. Do you foresee that that kind of methodology sneaking into the court system, where basically it will abolish, a lot of the tradition of having, a justice, having lawyers involved, and have it all automated strictly through AI and just the parties?
Yeah. Yes, and first of all, I agree. I mean, Colin, who you mentioned, has been truly inspirational, and he was right at the beginning. Before, in fact, that's where I met him, when he was going around the world for the ABA. I think this was towards the end of the last century. It sounds a long time ago. I suppose it was, really. And has inspired us all with the work that he did in eBay and PayPal, and his vision for it. And on that particular point, and by the way, he will of course be at Greenwich. But on that particular point, yes, I think that's more relevant form of tradition, that there is the important point of taking advice from people who know about these things, and having an opportunity to make sure people are able to be advised. So it's not only about technology to enable them to issue court proceedings or defend them, to be able to afford to do it, which technology can help them do, but there's also the need to be able to afford advice, legal advice. We've just been talking about the process of determining outcomes of disputes, whether in courts or out of court. But people need to know what the law says. And in fact, going back to our Civil Justice Report, Council report, of 2016, we did make a point of saying that there should be tier 1 facilities for people to understand the law, because really it's a weakness in any country's court system if people have to pay to understand what the law says. That it should be freely available for people to know what the law is. You shouldn't have to pay somebody to tell them. Perhaps pay somebody to interpret the law or any particular facts, and that in that way to give advice. And so I think there's a balance between what AI can do in guiding people into that advice. So I talked before about AI, generative AI that can guide on a value of a claim, let's say a personal injury claim, driven by the millions of other cases that have been dealt with previously. But also there's going to be somewhat the nuances of the law that therefore will mean there'll always be a need for lawyers, human lawyers, to interpret and guide and advise. I think you're referring also to the procedures of the court, the exchange of documentation, the exchange of information. We have a developing practices of conduct required of parties before they issue in court, in sharing information. As we know, Both sides can't be right in a case. There's always somebody's right and somebody's wrong, and often it's more nuanced than that. But helping to understand whose position is more likely to be the correct one is something that parties can be better advised when they have full access to the documentation the other party have, and vice versa. So I think all those procedures are important, and I'm sure can and are being incorporated into management system. I can just say one of the disappointments I have with the progress of ODR is how most of what the courts, I mean, it's great that the courts are opening these systems and thereby giving better access to justice. But most of the systems are really case management systems. They're there they've got online access to file, that's important. But there isn't an awful lot happening that will help parties to resolve the disputes. I mentioned the Smart Settle one, which is a form of visual blind bidding. That does that perfectly well. We need more of that, more of systems that really express that final letter R in ODR. It's not just online, it's not just disputes, it's about resolution. And where technology will actually help the parties resolve, that's the greatest contribution.
Awesome. Well, gentlemen, thank you so much for this talk. And thank you, Graham. So we're looking forward to seeing you again. Hopefully, it's going to be in Greenwich in April of
Very
2025.
well.
Yes. And we'll definitely wait for you to give us that information. So we'll share it and blast it out so other people can know about it, the conference as well. All right.
Okay.
And yes,
Well, it's been
sir.
a pleasure. Thank you very much for inviting me. Bye-bye.
Absolutely. Yes. And Thomas,
I don't
thanks so
know
much.
where the red button.
Oh, exactly. Well, one
Oh,
day we'll
I've
do
got
it
a
in
red
person.
button. I've got it here. I'm going to leave now. Bye-bye.
All right. Take care.